Hi everyone. Today we're going to be talking about victims of criminal activity applying for the U visa. My name is Ruby Powers. I'm a board certified immigration attorney with the Powers Law Group. I've been practicing over 15 years and the law firm's 14 years old. And we are a full service immigration law firm that can help individuals around the country, around the world on U.S. immigration matters. So, what is a U visa? What are crimes that qualify? How do you qualify? And just sort of how does this process work? So let's go ahead and do it. Let's dive in right now. So what is a U visa? So it was created around 2008 and then later clarified with more guidance. So it's been around about 15 years actually. It is to help individuals who are immigrants and who don't have a status in the United States to be able to encourage them to come forth with information if they are victims of a crime, a qualifying crime, with law enforcement, and to be helpful to law enforcement and government officials in the investigation of prosecution of criminal activity. So this was created to create more of like a line of communication, and for individuals not to be afraid of communicating with law enforcement. So there are a lot of specific requirements to it. So let's go ahead and talk about that. So you're a victim of a qualifying criminal activity. You've suffered substantial, and we'll go over what those crimes are, substantial physical or mental abuse as a result of having been a victim of that activity. So you have to demonstrate that usually with like a therapist note or letter, or something along those lines, or your affidavit, treatment. You have information about the criminal activity, and if you're under age of 16 or unable to provide due to disability, parent, guardian, or next friend may possess information and communicate on your behalf. Now, if you are helpful, or likely to be helpful to law enforcement, so that's very important. And if you are under the age of 16 or unable to provide due to disability, a parent, guardian, or next friend may assist on your behalf. And the crime occurred in the US or violated US laws. Okay, so the level of crime is quite substantial, actually. No one would want any of this to happen to anyone. The ones that we commonly see are domestic violence, especially when the aggressor is not a U.S. citizen or legal permanent resident. Otherwise, we would consider doing a a VAWA. The other thing we see is like a felonious assault. So usually it's an assault rises to a felony when there's like a gun or a knife or something along those lines. A lot of these other ones we haven't seen as much, but they do come up, and unfortunately. I mean, we've had a lot of different U visas cases. I'm just saying those are the ones we normally would see. The other thing is other related crimes. So if you can demonstrate that there's similarity between um, one of the crime that was happened to you, you were a victim of, to one of these other ones, then you can argue that it is a qualifying crime. And so this is the list. Now, the process is that there's two parts basically. First is you request a certification. So you submit the I-918 Supplement B to be authorized to the authorized official that is the certifying law enforcement agency. So like in some counties that are really big, they might have one email, one office, one location that you send all your requests to, like we have here in Harris County, for example, where we're located. But then there's other places, like other counties and states in the country that are not very familiar with these. And we've had to educate them actually about this and give them a lot of information about USCIS. So depending on the requirements of that certifying agency, they might want you to fill out most of the certification. They might want you to keep it blank. They might want a personal statement. They might want more evidence. Some locations make up these arbitrary deadlines and say you had to have done it within 2 years, 4 years. We've had one certified, it was almost 20 years old in North Carolina. So, it really depends. So I would say have someone help you that has experience with U visas. And we have a lot of experience, but we also have a really good network of attorneys around the country that we can ask for guidance and help for specific areas if there's something that we need to figure out. So first, you send the certification request. Now, they might take forever to send back a response to say yes, no, but they might say no because of whatever and go to another agency. That's happened. You have to be diligent. You have to watch when you request it. We assist individuals with this process. But the big thing to note is that once it's certified, it'll be and signed. It's good for 6 months. So there's a clock there. And so those 6 months, you need to submit the rest of the application, which is the rest of the I-918 application. And you might also need to submit a waiver if you entered illegally or have any other inadmissibility as well. Now, when you're filing for certain relatives, if you, the principal, are under 21, you can include spouse, children, parents, and unmarried siblings under the age of 18. So that's a lot of people. But if you're over 21, 21 or older, you can only petition on your spouse and your children, which is still a lot. And so then they can be under this application as well. So certain individuals are eligible for the derivative status, and the principal must have their petition for a U visa approved before the family can be eligible for their own derivative U visa. But you can submit the application and show the family members and list them as well. The petition for a qualified family member, you must file a I-918 at the same time as your application, or you can submit it later. So that is also a good thing. Like if you get married later and you want to add that spouse to it, you can do that. So that's a possibility. Now, when the non-immigrant the U visa is granted, it's valid for 4 years. And you could get extensions in limited circumstances. But after but the goal would be to submit your application for a green card. So that would be what you would want to do. So after a certain amount of years, you're allowed to, of having the U visa approved, you're allowed to apply for legal permanent residency. Now, this is where there's two issues with U visas. One, it's unfortunate to be eligible. You have to be a victim of qualifying crime, which takes a toll on a person, and there will be working through trauma and therapy and all of that. So, it's definitely an unfortunate situation. But the second unfortunate situation is that there's only 10,000 visas available every year. 10,000. So after this program got kicked off in 2008, actually took a little while for all the procedure and the guidance to come out. So it wasn't even eligible to apply for a little bit later, a few years after that. But then once word spread and people found out, then people started applying because they were eligible for this in the past. Just like I mentioned, that one case that was almost 20 years old, and we got the certification. So now, when we filed a few years ago, people are now getting those cases approved. But the word on the street is that it's almost going to be a 15-year wait for people who apply now because of just the visa limitation. When there was talk about reform at different times, right? One of the things they suggested was to increase this number to a whole lot more so that there wouldn't be such a long wait. But anyway, this is part of the unfortunate aspects of the U visa is the U visa cap. Now, one thing that did come out a couple of years ago is that they are allowing people to apply for work authorization under a deferred action. So you don't have to have the U visa approved before you get the work authorization. It's taking a couple of years after filing it to be able to get that approved. But that does allow people who have U visas to be able to, U visa pending, to be able to have work authorization. When you get work authorization, you can get a real social security number for taxes, for credit, bank accounts, lots of good stuff. And also in certain states, you're not allowed to get a driver's license unless you have status. And showing that work authorization shows you that status, if you will. So back to the adjustment of status, we were talking about after you've had the U visa for a few years, then you're able to apply at least 3 years. So we'll walk through the requirements here. You can apply for legal permanent residency. So you had to have been lawfully admitted in the U1. You're in U1 at the time of applying for the green card. You've been physically present in the US for a continuous period of time for at least 3 years since you were admitted in the U1. So if you happen to leave the US, then that would not count for your time for the U after the U is approved. You must have at least 3 years of continuous presence at the time you file the green card and must continue to be physically present through the date the USCIS makes a decision. You have not unreasonably refused to provide assistance, so they could still ask you for assistance, and if you refuse, then you wouldn't be eligible. And you're not inadmissible under 212A3E. Your presence is justified on humanitarian grounds. It's in the public interest, and you merit a favorable exercise discretion. So that could be a place where if you have other crimes and issues that they might say, I don't want to give this to you, but I haven't really seen that, because one other thing about the U visa is that it waives almost everything, almost, but there's discretion, right? So if you have a permanent bar, the U visa waives that. You can get a waiver for that. If you had false claim to citizenship, US citizenship, you can get a waiver for that. So the U visa, in that respect, even though it takes a long time, if you're filing now, it is very generous for the waivers. There's basically no other than probably a T visa that can give you so much leeway. So that's a U visas in a nutshell. We want to be available for you. You can reach us at rubypowerslaw.com or our number 713-589-2085. And we have moved a year ago to 1311 Enid in the Heights area. We have multiple attorneys speaking different languages. We're going to do this as well in Spanish. And so feel free to add yourself to our newsletter, share this with a friend, family member, somebody who could benefit from this. And I'll just say I volunteer at the Mexican consulate all the time. And I constantly find people, and even through my consults, when we're talking about something else, that are eligible for this. So I would just say is if you find out you're eligible for this, don't delay, because what I've noticed is that some law enforcement agencies they will make these deadlines and say if it's outside so many years that they won't certify it. So certification is that first step. So it's really important that you get it done in time. So thanks for watching. If you have any questions, feel free to call us for consult, reach out, sign up for the newsletter, and we'll see you next time.